SJC-13647, Commonwealth versus Shawn Tanner.
Okay, I'm just going to let some of this coming and going before you get started. Okay, Attorney Mark.
May it please the court, David Mark for the Commonwealth. Our argument that the motion judge had no discretion to deny our motion to vacate has two parts. The first is that there is an ordinary rule that pending proceedings in criminal cases, particularly collateral proceedings, are vacated by the death of the defendant. And the second part of our argument is that there is nothing in the text or legislative history of 278A that would, from which a legislative intent to deviate from that practice can be inferred. I want to start there because I think it's the more controversial of the two components of the argument. So there are, in effect, negative and positive evidence to be drawn from the statute. The negative evidence is simply that it doesn't mention this eventuality at all. And I would add, both we and the defendant and amici have combed the legislative history pretty carefully, and I see no evidence in the legislative history that this was ever contemplated. It certainly doesn't seem to be mentioned. So there's that as a start.
Well, it's really not as a start. The start is the text of the statute. And you're reading into the text of the statute a termination clause that has language in it that commands. It has shall, right? This isn't even a may. This is a shall. And in a shall textual statute, you're reading into this a termination clause.
I would quibble with that characterization, Your Honor. In our view, there is in effect, a standing body of law that pending proceedings terminate. And the question we ask about the statute, is there anything there, including the mandatory language, that would cause this court to deviate from what is otherwise the ordinary practice?
Well, the ordinary practice you're pointing to is a collateral attack under Rule 30, a motion for new trial. This is a statutory remedial scheme that's a little bit different. So the legislature decided in its wisdom to pass this statute with a really low threshold that we've talked about in our case law to afford defendants the opportunity to, in effect, press their Rule 30 motions. And so that's a little bit different here. So now we have this statute that's been enacted, and again, there's no termination clause in it. And so doesn't that work against you?
No, it doesn't. In our reading, where the statute simply doesn't contemplate this eventuality, to address in particular your point about the mandatory language, our reading of that language is simply that it's necessary for the statute to operate correctly in those instances that the legislature clearly intended that it operate.
But did the legislature intend for there to be a separate and distinct proceeding under forensic testing?
Yes.
In new trial?
The language of Wade and Wade's reference to the statutory history makes it clear. It is a separate proceeding. I would argue that the reason it's a separate proceeding is to avoid what Representative Fernandez called the chicken and egg problem, and I've called the catch-22 problem, which is that under Rule 30C4, you have to make a prima facie showing in order to get access to evidence. Here, the problem is solved by making the statute separate. But I don't think we can read beyond that significance into the fact that it's a separate proceeding apart from a Rule 30 proceeding, except to address that problem.
These are incredibly unique situations because the statute certainly contemplates a living defendant to file, correct? I don't think there's any dispute about that. So here we're talking about, in this case, a very unique circumstance where someone who presently was alive files and then is deceased, correct?
Correct.
Then why doesn't the mandatory language of shall, as Justice George's point out, carry the day?
Because you can't draw an inference from the mandatory language if the mandatory language is necessary anyway to make the statute operate correctly.
May I ask you a question that's driven by the procedural posture we're in? And correct me if I have any piece of this wrong. There was a motion that was assented to regarding the forensic testing.
Correct.
And an order entered as a result, correct? Then there was a subsequent motion to vacate.
Yes.
The motion to vacate is reviewed for an abuse of discretion.
Well, we argue in this case that the judge didn't have discretion. That's in the first
Okay.
instance.
And let's just assume for purposes of my question that at least I think that the standard of review for a motion to vacate is whether there has been an abuse of discretion or other error of law. And then I'd like you to address the following, if you wouldn't mind. There's no argument here that the original order entered improperly. There's no explicit termination in the language of the statute. There seems to have been somewhat slow compliance with the order on the part of the Commonwealth. And there's a third party who's paying for the cost of the testing. Why in those circumstances did the judge abuse his or her discretion in denying the motion to vacate?
As the judge is saying, it was his. So first, I just want to flag that we quite strongly disagree with the characterization that there's inference of foot dragging on the part of the Commonwealth here.
Seems slow. I'm not saying foot dragging, I'm just saying it seems slow. It's my question, for what it's worth. So, I mean, but if that's the framework, if abuse of discretion is the framework, that's at least what I see the record might support in terms of the judge's thinking in denying the motion to vacate. And I'd like to hear why that falls outside the range of reasonable alternatives.
Our argument on this, essentially our second argument about if he had discretion, he abused it, depends essentially on our contention that the judge really needed to look at what purpose the testing would now serve in light of the defendant's death. If that's off the table, then in some sense, what really happens here is that given that there was a valid order for testing, there actually is no discretion on the part of the judge to allow our motion.
That's the inquiry, is to what end would testing accomplish? And what the defendants argue is civil liability, clearing one's name, et cetera. Could you address that part of to what end?
Yes. So because we're in the second argument, we get to look at the particular facts here. This is not a case where a testing alone can produce a definitive result of exoneration. It's simply not possible on these facts. So the defendant and amici talk about all of these possible remedies. What is the common denominator on all of these remedies? An unambiguous demonstration of actual innocence. That cannot happen here on the basis of testing alone.
Well, but they also say that we may have the wrong person, and say the stuff under her fingernails may be somebody else. Yeah. And that's their best argument, right? You didn't produce the fingernail that's underneath the fingernails quickly. That's the best evidence that maybe there's another perpetrator here. And, you know, the Commonwealth has an interest in tracking down the right guy. So that's their argument.
Right, which ignores the fact that they have to explain.
But if it comes up with somebody else under the finger, that's pretty damning stuff. I understand you've got a lot else on the other side, but that's that produces a reaction from the police, doesn't it?
It would certainly produce a reaction from us. If such an unlikely thing happened, we would certainly be curious about that. But the fact remains.
So
Isn't that enough? I mean, you're jumping ahead. If we did the testing, then we would definitely only get limited information, but you don't know that. You really don't know. I mean, I don't know what, you know that the scientific testing might lead to something that in fact helps the interests that are articulated by the amici and by the defendant, and stopping it short, assuming that it's going to yield some result that just won't be enough, when we know that the standard for this kind of testing isn't that higher standard that you're now imposing on whether it can continue. It just seems odd to me.
So let me just start in addressing that point by making an observation here, which really goes back to my first argument. This court has consistently said that the legislature set the bar for testing low, which makes perfect sense if the object of testing is a possible motion for new trial, because then.
I'm sorry, but we've had those cases. We've had the stray cigarette butt cases. We've had the DNA next to the body. We've had all those, and we can distinguish between that. But if you're looking at, as it's been raised, material under someone's, the deceased fingernail, that's not the stray cigarette butts on the side of the road. That's relevant evidence, and certainly enough has been indicated to satisfy this standard.
We're actually, the point I'm making is not responsive to what you're saying, because I've really gone back to argument one. If I sort of just finish that point and then adjust your question and Justice Wendland's question. In setting the bar low, that permits an inference that the legislature did not intend to reach a situation like this, because we know, and the legislature would have known, that posthumously the requirement to produce a vindication is much higher, as a matter of fact, because there can be no motion for new trial that would fill out the significance of the perhaps ambiguous test result.
But it's different when the person the defendant wants this done, as opposed to family members later on. Isn't there a difference here that we should take into account? I mean, whether he's going to engage in something that's completely futile, maybe, but it just seems
along the same lines, and going back to Justice Walhoden's question about the procedural posture here, I have a question about why this case isn't moot. So there was an order from a court based on a filing by a living person to get this testing done. That person then died. The Commonwealth moved to vacate the order. The judge refused to vacate the order. The Commonwealth is still subject to an order to test this material and has not sought relief pending appeal with respect to that order. So can you speak to that at all?
I think, Your Honor, you've got, so as you may recall in my brief, I posited three possibilities. One is that the judge had no discretion to deny our motion to vacate. The second is he had no discretion to allow it. And the third is that he did have discretion. I think you're really talking about the second option.
No, I'm talking about why hasn't the Commonwealth complied with the order that it is subject to, that it sought to get lifted, and that still is a valid order of the court in the absence of relief pending appeal. Is what's happening now, there's just further delay at the lab, and that are you contending that you don't have to comply with the court order because there's a question about whether the judge erred in refusing to vacate it?
Well, so that's a very uncomfortable question to answer as you posed it. I would say that if testing went forward, it would certainly moot this appeal. And because we were entitled to have the question answered, stopping the proceedings is necessary, or there would be no point. We'd have an answer.
So I guess, but there is no motion to stay that was granted.
There is no motion to stay that was granted. We did
You're
not
just
move
sort
to
of
stay
using
the order.
self-help, not producing the fingernail clip.
Sorry?
It's just self-help.
I'm not sure I would want.
Well, have the
that.
fingernail clippings been produced?
No.
Okay.
And just why? I mean, it just seems strange.
Yeah.
Posthumous proceedings aren't going to happen. Both sides agree you can't do that. This is sort of a limited instance, and we're dealing with potentially evidence that everyone would care about, what's under those fingernails. Why are we fighting this so hard? I just don't get it. Go ahead. What is the Commonwealth's interest in not finding out what's under those fingernails?
Your Honor, you put that in the most provocative way.
That's what we get to do, you know?
This goes back to the fact that everyone who, when we talk about this, we're not, I think, paying sufficient attention to, if we're talking about this case, let's talk about this case. There is no possibility that the DNA of a third person underneath the victim's fingernails in the CODIS database would exonerate that person in this case.
But there you go again, because now you're going back to the jumping ahead of Justice Wendland's question. And I'm going to put it to you directly because of something the Commonwealth did in this case. Part of what the universe of testing the defendant sought was objected to by the Commonwealth. And that was because all of the people that had touched particular pieces of evidence, you were afraid of transfer DNA and say, we don't want you to touch all this because it may be contaminated by all the people that have touched these pieces of evidence over the years, right?
Right.
Okay, so that leaves the stuff that's under the fingernails. One of the things, even though there was a miscitation to the supplemental record, is the letter in support by ADA Conley. And one of the things that ADA Conley talked about was this testing not only exonerated, but helped implicate. So if there's the testing underneath the fingernails and there's another DNA profile that similarly can be put in the CODIS and identify another perpetrator, that goes directly against what you just said to this court. You don't know that the testing won't identify another suspect that will then produce evidence that might lead to a conviction.
What I don't know is what the result of testing of the fingernails would be.
And why is that? Because you didn't turn it over.
Your Honor,
right? Right?
Yes, that is, as far as we can tell, a mistake by the state police lab. It's not. This is not our office or the state police attempting to evade a responsibility under the order.
But it still doesn't get to the heart of the question of why there is a need potentially to continue to have this done. And it's not what you said, that there's no universe where this particular testing could yield an exoneration of Mr. Tanner. You don't know that.
I would politely disagree with that.
So if there's another DNA profile underneath those fingernails and it leads to another hit in CODIS?
I'm just asking a rhetorical question, which I don't want to do.
It could lead to a follow-up investigation. Yes, in and of itself, it won't exonerate him, but it may lead to follow-up inquiries that could result in something that you're not expecting, and,
right.
And you can resolve that problem.
This is if the standard is anything is possible, then we lose.
That's here. Not that. This is not anything is possible.
But with all due respect, Your Honor, if I may just briefly address the evidence here, Mr. Tanner confessed to his friend Medeiros that he'd done the crime and gave him.
What if it's Medeiros' fingernails? What if it's Medeiros under the fingernails?
That would account for all the information. It's true, that would account for all the information.
That might make you take a second.
But well, except that
I'm not saying it is. I'm just saying
we know about. I mean, we know from the facts that he would have an alibi, and the defendant's own testimony puts the mysterious stranger coming into the room that he left while the victim was still alive, not his friend Mr. Medeiros, who we would have every inclination to, to throw under the bus if there were a bus to throw him under.
Okay.
I seem to be well over on my time. Thank you, Your Honor.
Thank you very much.
Your Honors, and may it please the court, my name is Jessica Dormitzer. On behalf of Shawn Tanner, I'm joined by Jack Lange. The Commonwealth presents two questions to the court today. Did Mr. Tanner's death require that the Superior Court's testing order be vacated? And second, did the Superior Court abuse its discretion by denying the Commonwealth's?
Can we set the parameters and be real clear that the case we're deciding today is a very narrow one involving people who are alive at the time of a filing of a 278A motion, correct?
Yes, Your Honor.
It doesn't cover everyone who wants to have the case opened up on behalf of loved ones of people who want their cases opened up, correct?
Correct. Specific circumstances here, I don't see a floodgate issue.
I have a question about, that's also a consequence of the unusual facts, which is that your client has died. Do you continue to, technically speaking, do you continue to represent your client? Because I always thought the rule was your authority terminated with the death of the principal. And depending on the answer to that question, I'm wondering whether Mr. Tanner's representative has retained you to pursue these claims on behalf of his estate.
It is unique. We do find ourselves in unique circumstances. We assisted with the representation of Mr. Tanner before he died on a pro bono basis, and we assert that we should continue to represent his interests on a pro bono basis.
You have authority for that, because I took a quick look and I see only case law that says that the authority ends upon the death of the client.
Your Honor, I don't have authority to it, and you can accord the weight of our argument accordingly. But it seems fair that someone should be able to represent.
Well, it's not just the weight of your authority. It's not just the weight of your argument. It's whether you have the ability to appear on behalf when you don't appear and argue when you don't have a client.
I understand, Your Honor, that assertion has not been raised to date, nor has it been briefed. So in the interest of somebody representing why the Superior Court's order should stand, I implore you to.
Did you try to get a representative or to have yourselves appointed as his representative for these purposes?
No, Your Honor, because we already represented him before he passed away.
Right, but there's a difference between having a living client, right? I mean, you don't need to do that when your client's still alive, but once the client is dead, I don't know of any circumstance where an attorney can operate without the authority of the decedent's representative.
Does that then mean, though, that no one can represent Mr.
No, it
Tanner's
means
interests in this
that you would
proceeding?
have to go to the representative of his estate and seek relief that way.
I'm not sure we're the territory of a successor to Mr. Tanner's interests, where the Commonwealth initiated this appeal, and all we're seeking is that the order that the Superior Court entered, it was a final order, it was a non-appealable order that the Commonwealth didn't abide by. All we're asking is that that order remains standing.
Right, but you could have gone to the probate and family court and had yourselves appointed a limited purpose representative for the sole purpose of doing exactly what you're doing, which is pursuing this, opposing this appeal, or in fact, pursuing every action you took down below after your client died. That may be possible to do nunc pro tunc, but I don't see how we can, I'm just raising the questions here.
I guess the question also, in Hernandez, do we know who brought this, whether it was done by the lawyers who were representing him when he was alive, as opposed to what Justice Walhogen was talking about? Because I'm just glancing at it right now, and I don't see this issue being addressed. So it may not have been so clear.
I believe, Justice Kafker, to answer your question, that there was a footnote in Hernandez noting that this issue was not raised in Hernandez.
Okay, yeah.
But we're going to move on from it, but I just want to make sure that you understand that it's not just esoteric. Because assume for the sake of argument that this is affirmed and the testing is ordered, who does it go to, right? So you have issues of who's the recipient, you've got issues of chain of custody, and you've got issues of confidentiality. So you've got all of these issues that stem from whether or not we have the real party in interest.
This 270, sorry, Your Honor.
No, I'm just, that there are real implications to this for us.
Under 278A, the results of the testing goes to more than just the moving party. The results of the testing also go to the victim, and the victim is defined broadly to include her estate or administrator if she's deceased. It also goes to the court. It also goes to the prosecutor. And that implicates the wider interests that are meant to be addressed in 278A.
It doesn't implicate, that was a to what end question. It doesn't implicate the interests of anyone to bring a lawsuit, for instance, correct? Because there's no legal representative of the defendant. Wouldn't get the results.
a lawsuit, I think,
You wouldn't get the results.
well, that'd be nice.
No, you wouldn't, right, under the statute.
The moving party, as you pointed out, gets the results, but a bunch of other parties get the results too. And those are all constituencies that have an interest in what the results are. And the fact that those constituencies exist, and it's not hypothetical here. We have an amicus brief from the families of the victims of the New Bedford.
Of other cases, no, you don't have anything from the decedent in this case, correct?
Anything from the decedent
In this case.
that says, I'm
Right.
sorry, I'm
There's
not
no-
following your question.
The person who is deceased in this case is not one of the people in the amicus brief, correct?
Correct.
So you're not arguing that you should not look into getting the proper,
We can certainly look into getting the proper authority to continue to represent Mr. Tanner.
You may also have a waiver argument, because Hernandez, it wasn't raised, the Commonwealth brought the appeal, and we considered it, which is exactly, seems like what happened here.
it's raised. Oh.
So if you could move on to the separate nature of Rule 30C4 discovery and 278A forensic testing, right? We know that that was a chicken and egg with this, as we described in Wade. That was why we have the statute. But in the legislative history, and as we discuss in Wade, et cetera, all of these cases are geared towards the ultimate filing of a motion for new trial for exoneration, correct?
I think a moving party certainly is interested in vindication. I mean, certainly if you're pursuing 278A testing, you're hoping for vindication in some respect. But 278A does not foreclose other means of vindication, nor does it require.
In the legislative history and our case law, is there anything that discusses civil wrongful death liability?
I don't know of anything, but I think that is several steps ahead of where we are. All we're trying to do is to uphold the testing order that still stands that the Superior Court issued. What the ramifications of the results of those testing are is several steps beyond where we are now.
It's the purpose of the testing, though, and as the Commonwealth argues that the purpose of the testing is now that to vindicate his or to exonerate is now a moot point, his death.
The Commonwealth, let me point out the important point that the Commonwealth agreed to the testing, and the Commonwealth admitted at the hearing that there was probative value to the testing taking place. For example, for the reason
I don't have any quibble with that, and I don't have any quibble that these aren't straight cigarette butts. This is biological matter under the decedent's fingernails. I get that. My question is, when we look at the legislative history, we look at our case law, all discuss criminal exoneration, correct?
The case law, what Wade says, the purpose is to remedy injustice. And there are other ways to remedy injustice besides moving for under Rule 30. And in these circumstances, there could be gubernatorial action, there could be legislative action, there could be an informal apology, but there also could just be obtaining information that furthers the truth. And here, the real possibility that there's a third party's DNA in the fingernail scrapings is extremely probative, especially where the evidence at trial relied on Mr. Tanner's friend, Stephen Almeida, and what Mr. Tanner told him.
You want us to read that into the statute where it hasn't been read in before, correct? The purpose of the statute.
That I want to read in what, Your Honor?
This other than criminal exoneration, these other factors that you mentioned.
Well, the statute doesn't have anything in it that says what's supposed to be the consequence of the results of the testing. There's no obligation in the statute to move for Rule 30. The only thing the statute addresses is the testing taking place.
Again, every time we've discussed the statutes in context of exoneration, criminal exoneration, there's nothing I've seen in legislative history nor our case law that discuss these purposes other than exoneration.
I don't see, starting with the text of the statute and this legislative history, I don't see that link between 278A and Rule 30. And in fact, in the legislative history, it says that what the legislature sought to do was separate those two things because of the difficulties under Rule 30. So therefore, under 278A,
with an end towards exoneration.
there's an end at least towards identifying more information that may lead to exoneration. And here, if Stephen Almeida's, the friend's DNA were found in the fingernail scrapings, that would be extremely probative of reopening an investigation that could lead to evidence that could exonerate Mr. Tanner.
So that leads to a practical question then. What test are you asking us to announce? Because if what you're saying, is it a categorical approach then that you always get to continue on, or is it going to be a discretionary test where what are we supposed to do with that?
I think the test already exists, that the test of whether the Superior Court properly denied to vacate the order is abuse of discretion. And abuse of discretion is assessed with respect to the circumstances of the case. And here we have circumstance that it was an order that the Commonwealth agreed to. The Commonwealth knew that Mr. Tanner was at death's door when it agreed to. It admitted to the probative value of the evidence. It didn't appeal the testing order, but nor did it comply with the testing order. And then the backdrop of that is the statute itself that implies that once the testing's order, it shall proceed. It shall take place as soon as practicable. Certain parties shall get the results. When you look at all that and assess abuse of discretion, it seems hardly an abuse of discretion for the Superior Court to say, Commonwealth, you agreed under these circumstances, now you must follow through.
So your position is that the judge could have allowed the motion to vacate the order to continue testing or to do the testing, but in these particular facts, not doing so, not allowing the Commonwealth's motion was not an abuse of discretion.
Correct.
So there are some circumstances where the judge could have exercised his discretion to not allow the testing to go forward.
I have a hard time saying that the judge that issued the order had no discretion in either direction. I think the judge has discretion based, and that is assessed against the circumstances of the case that are before the Superior Court.
That is contradictory to what you just told us, that the statute says shall test.
Well, I said that
Shall is mandatory, so how does the judge have discretion in that instance? I know you want to answer the question that the judge has discretion, but you just told us 3 minutes ago that it shall test. Which one is it?
I think the backdrop of the statute implies that the testing shall continue, but admittedly, the statute doesn't address this particular circumstance. So we're drawing intent from the language of the statute, which implies that testing shall continue.
But testing shall continue, but that also ignores our statutory construction language that says you can't just look at all this stuff in isolation. And there are other provisions in the statute that plainly contemplate a living move-on.
The standing requirement contemplates someone who's living at the time and also someone who's incarcerated at the time. And you can certainly think of circumstances where someone who satisfies standing at the time of moving may not satisfy standing by the time testing is completed. If I'm convicted and I'm on supervised release, I have 6 months of supervised release left, I can move for 278A testing, and it probably won't be completed by the time my supervised release is over.
Yeah, but that's not real, because even though you're released from a custodial sentence, you still have the other vertical of you're challenging the underlying conviction. So there is still to Justice Gaziano's point, there's a reason why you want to continue this, and
And there are reasons why other constituencies wanted to continue the testing in this
But
case.
it seems incredibly odd to me that you're arguing to us, the analogy you reach is someone is done with supervised release. They're a month off of supervised release. That person doesn't get tested, as you just told us. But a person who's deceased gets tested?
The person who's a month off supervised relief does get testing under the statute because standing is determined at the time of filing. And Mr. Tanner met that requirement. In Johnson, this court underscored that the standing requirement applies at the time of filing. And there's no reason why the testing shouldn't proceed. The Commonwealth has not yet articulated a public policy served by not doing the testing in this case when there are constituencies who'd like to see the results.
Would it be different if the government was paying for the testing?
That certainly would increase the burden on the Commonwealth slightly, but it's not the circumstance of this case where there's very low cost of complying with a court order.
But there's another thing that you just said that you said it pretty blithely, but it's important. You're saying that as part of our calculus, we've got to worry about all of the other people that may have a dog in this fight? You said constituency. So you mentioned earlier that there may be other folks that are interested in some other unsolved murders and that this would somehow implicate their standing for you to present what their concerns would be? That's part of our calculus?
Part of your calculus is the purposes of 278A to remedy injustice. And the interest in having information that's available serves a bunch of other constituencies. Here we have an amicus brief from concrete parties, but it's that general backdrop of the purpose of 278A that I think does inform your decision, Your Honor.